We don't need music. We're good. Right?
You're welcome.
Okay, well then we'll just get started because I think we have a lot that we want to talk about, and it's a lot of fun. And we chose tonight to do more of a collaborative discussion because I think we're all tired of the slides and the attorneys or the doctors bragging about themselves. Tonight is really more about talking about how we're going to change the future of personal injury and working together to do so to make a much better environment for our clients and for our patients. So with that, my name is Brett Sachs, and I want to sincerely thank Doctors on Liens and Injury Institute for allowing me the opportunity to be alongside some of the greatest providers out there in personal injury. There's probably decades of experience in medical and legal knowledge here that we're going to hopefully share with everybody, and we want to get the attendees involved a little bit as well. So if you along the session here, if you have questions, please reach out in the chat, and we'll make sure that, or the question and answer, we'll make sure we try to address everything. I own a mid-size, decent volumed personal injury law firm in Irvine, California. We are statewide. We handle cases from all over the states. And we do specialize in resolving cases for fair value or full value in certain circumstances when we're not dealing with limitations, and getting our medical providers paid, and done so in a very reasonable time. And our average caseload is going to resolve in under 6 months and certainly under a year. But we work with providers. We want to make sure that we discuss and communicate with our providers the necessary information needed so that our clients can get the best care possible and resolve the case for full value. And with that said, I'd like each individual doctor, starting with Dr. Garcia, just because you're the first on my list when it comes to how I see you on the screen. Introduce yourself, tell me where you're at, how many years of experience you have, and a little bit about yourself.
Thank you, Brett. I'm Dr. Garcia. I've been practicing for about 17 years now. I've been doing personal injury since I opened my practice in 2003. My practices are located in Victorville, San Bernardino, and Rancho Cucamonga. I am married with 4 children. My oldest is 16 down to 10 years old. 3 boys, 1 girl. Love sports, love seeing patients, love overseeing my practices, and that's about it with me. I graduated from Cleveland Chiropractic College of Los Angeles in 2003.
Great. Dr. Bertano.
Yes, Anthony Puritano, Integrated Medical Center. Our practices are located, our main office is in Corona. We're in San Bernardino, Hemet, Chino, and Wildemar. Married with 3 kids all in college. Can't wait till I get a raise here soon when they're all done. But practice, we're in a multidisciplinary practice. Dr. Sandifer, Terry Sandifer is our medical director. And we do everything from chiropractic, physical medicine, we do PRP, etc., acupuncture, spinal decompression, just about everything. I've been practicing for about 30 years. And again, love what I do. And been fortunate enough to surround myself with good people that allow us to be fairly successful.
Wonderful. And pardon our interruption. We'll be bothered here by Chloe every once in a while. Her mom's not in the house yet, so she's a little needy. So hopefully she doesn't bother anybody. But Dr. Tabarisi, is that how you pronounce it?
Yeah, Tabarisi. Yep.
Perfect.
Yeah, I've been in practice 10 years. This is the 10th year now. So we opened up in Costa Mesa 10 years ago. And then last year, actually 6 months ago or so, we opened up in Long Beach. My brother came out of chiropractic school, so we were able to kind of keep it in the family and open up a second practice. So.
Awesome.
All right.
And last but certainly not least, Dr. Razapur, by the way, before you say anything, I want to commend you. I am very much a supporter of very successful, powerful women in our industry. And what you've probably had to overcome to be sitting where you're at today deserves a hand of applause. And so thank you for being part of this. And I sure hope that all the women lawyers and staff and chiropractors and doctors out there understand what it is that you do to help the movement of equality within the legal and medical profession.
Hi to everyone. I am a chiropractor over 16 years. I graduated from Cleveland, LA, and I have 2 locations, one in downtown LA, South LA, and then one in Woodland Hills. And then I believe the success of my practice, patient care. And, you know, I get most of my clients from referral of the old patient, you know, referral base. And thank you for having me here.
Thank you so much. Before we kind of get into anything, is there anyone with any initial questions about how we can change the nature of personal injury in the future for the better good of the client and the patient?
I'll tell you right now, I think it's dialogue. We chatted on that a bit earlier. I think a lot of chiros, especially ones that are a little more inexperienced with personal injury, are a bit intimidated by the process, or at least communicating with the attorney. And once you open that communication and find out what you guys really need and expect from us in the way of documentation, you know, we have medical standards we have to obviously subscribe to, but you guys give us some direction on the format is helpful. If it's going to help you a certain way, that communication is huge.
Right. So I'm going to ask a couple of questions, and I definitely want the attendees to step up and ask questions along the way as well. And I'll preference tonight's webinar with an apology. If anything comes off the wrong way, it is all meant in the best interest of working together for the better good of this profession. But what I have to ask is, of the chiropractors on this panel, how many lawyers do you guys work with on a regular basis where the vast majority of your bills are paid in full or near in full?
Mine is paid about 60 to 70%. I don't know about you guys.
Yeah, it's very rare. I have gotten paid in full, but very rare that happens. But on average, I would say literally it's about 40% right now.
Okay. 40%, 60%, Dr. Curatano?
Yeah, you know, the ones I choose to work with obviously are higher percentage of paying us in full. We get referrals from firms all over California, but those we know who those players are, and whether they, again, we don't expect much with regard to how they work a case up. So, you know, it's, again, I think with Dr. Razapur, I think we're similar with the attorneys we work with consistently. In other words, where we refer clients to. But on the incoming side, it's probably 60% at best.
And what about you, Dr. Tabrizi?
You know, when we first started practicing, again, we've been practicing for about 10 years. We picked 2 or 3 attorneys that were just right out of school, you know, who were just kind of starting off, and they had new practices, and then some who were big players. So it really depends. It depends on we usually, the lawyers who pay us in full, we don't really get a lot of cases like you guys are mentioning. A lot of cases back from them. So we refer out, they take really good care of the patient. We get paid in full, but we don't get referrals back. But the younger attorneys, the ones who are not as high volume, they, you know, handhold the patient, they take care of it. There's a lot of dialogue, and it's about the long-term relationship, right? It's about like building it over time and making sure that you kind of stick to the people who are not only loyal to the process, but loyal to the patient, loyal to the doctors, and vice versa.
Wonderful. And for the ones that do not necessarily pay you in full on a regular basis, what is the average time frame that they even start negotiating with you on your bill? And then what is the average payout, do you believe, you know, from 30 cents on the dollar to 70 cents on the dollar? What do you end up seeing down the road, and what information are they providing to you?
I mean, there was just one this past week. It was shocking, man. We got a check back from 2015, 5 years ago.
Wow.
So, those kind of make your blood boil a little bit. But again, for the most part, we're waiting about 2 years, maybe a year and a half to get checks in the mail. So, we were talking earlier about getting checks in 6 months, and that's really music to the ears, because that's not the way that it is in the system right now.
What about you, Dr. Razapur? You said about 60% you get paid in full. What about the other 40%?
It's about 30%. The settlement is just like, what is the total settlement? I ask for all the attorney to give me a breakdown, and then based on the fair basis. Like we are a smaller provider, we provide treatment compared to the other doctor. Usually the 90% of the regular insurance company, they charge, if the consultation for specialist is like a 300, 400, they charge like a 3,000, which is not fair. I ask for the fair amount, and then if they don't willing to work with me, I don't see their patient anymore. As simple as it is. My mission is a patient care, and then usually I get a lot of referral through patients. If they're not willing to, pay me on the fair basis, there is no need for me to see their patient.
Agreed, 100%. What about you, Dr. Garcia?
So we do the same thing where we get the breakdown of, the settlement, total meds, what's my bills and so forth. And, normally it's about 6 to 9 months that we get paid. Now, of course, there's other cases that take longer. My question to you is when they tell us the total meds, do you think there's some attorneys that might be fudging those numbers a little bit of what really the total meds are?
Yeah, I mean, that's a great question. And in no way do I want to infer as to what another firm's intentions may or may not be, but I can definitely assure you that sometimes when they're giving out information about total medical bills, they do provide the total billed medical bills, which might not reflect exactly what ends up in the client's pocket, because they're asking for a reduction because they want to obtain the most compensation for their client. And a lot of times by providing medical billed amounts versus what the settlements have been or what we're looking at isn't necessarily fair as far as what translates to what they're going to deem as probably pro rata, which is another thing I'm definitely wanting to get into tonight, is understanding and defining what I believe pro rata means in your realm, and how you guys should be able to address it when somebody brings that term up to you. If there's a $15,000 settlement and there is a $5,000 or $6,000 or $7,000 hospital bill, and your bill's $3,000 or $4,000 or $5,000 as an MRI bill out at $1,700 to $2,400 depending on the center, and you have a collective billed amount which is over that policy, and they're asking you, based on X amount of dollars and X amount of money in the pool, that you should take X amount on your bill. Well, at the end of the day, is that truly fair? Is your billed amount per session equivalent to, let's say, an MRI bill or a pain management physician's consultation? Their one bill is $1,200 for a pain management consultation on average, and sometimes 10 visits could be $1,200. So how is it fair that you guys take the same amount of reduction, quote unquote, pro rata, as a specialist or an MRI center or a hospital that's probably being reduced with health insurance to almost nothing? And at the end of the day, what I think is most important is pure communication between the firm and the provider. And a lot of times, there's certain things that we can't necessarily provide due to attorney-client privilege, but I don't want attorneys to utilize that privilege to disguise and mask everything, if that makes total sense. And there are certain things that we are allowed to provide to you if we're asking you to take a reduction. And I'm sure everyone on the panel has liens that they have the clients and attorneys sign, and the good liens out there are going to allow the patient to sign off on us providing certain information without waiving privilege, of course. And with that, we should be able to communicate. If we have a situation with a high hospital bill and that is reduced significantly through health insurance, and my client can still end up with 30 to 45% of their settlement, and that means that I can pay you guys in full, then what is my obligation to ask you to take a reduction? At the end of the day, my goal is to advocate for my client, and that includes both net recovery as well as the right care. And I think that there is pure value in getting the client better. And the clients, they should be communicating with their attorneys to understand what that means.
Brett, it looks like we have our first question from Dr. Kent Choi. And they ask, what are some frustrations you run into with chiropractic providers? And also, what are some very good things you see in chiropractic providers?
Well, for us and for our firm, I think that, again, the future of personal injury when it relates to chiropractic care is really value driving a case through a collaborative medical team and becoming the primary care physician on a personal injury case, so that at the end of the day, us as attorneys are not dictating where the client's treatment is going, but providing you, the primary care physician, with the right information to obtain the right care and the right results. So some things that we end up seeing that can end up not necessarily destroying a case, but can definitely devalue or hurt a case in some aspects, is when the chiropractors keep care too long. And most of it, in my opinion, is based upon fear from what I've heard. I believe that chiropractors are scared to give out their patients to other providers, so that because they're afraid that they're either going to not have enough to get their bill paid, or that they're not going to get that patient back. So what I would ask is the panelists on here to I'm going to throw the question on to you and ask you guys, what are some certain things that you've seen or that you've done that have gotten good feedback and maybe bad feedback from the attorneys that you work with?
Well, if I may, and Brett, ask if you practice this, is one of the biggest, not frustration, but that helps us manage cases well, is if we know the policy limits early in the case. Now, we know by law they don't have to disclose it, the insurance company, but I know a lot of attorneys, not a lot, but some, have ways to find out the policy limits. So what do you feel about that?
I feel it's vital, absolutely vital.
Yes.
We obtain policy limits within weeks of obtaining the case if we have the right information. If not, we get our client's declaration page very quickly. And it is our job to communicate that with you. I absolutely think that without that information, you guys are in the blind, and it is impossible for you guys to treat a patient. I mean, Dr. Razapur, the attorneys that you work with, are you able to get that information, or are they kind of asking you to trust them along the way?
You know what? I usually do not communicate with the attorney unless the treatment is a costly treatment, if the patient needs surgery or MRIs. And, I just, at that point, we communicate with the attorney's office to see if the patient able to do surgery, or, if it's a TBI case or the fund is available. Usually, I send the patient, I treat the patient, send it for 1 or 2 MRIs, and then at the time that I find the patient has serious, injuries and need the, costly care, we can contact the attorney's office.
Okay. That brings me to, I'm sorry, Dr. Bertano, do you have something to say?
Real quick question. What's the average time frame to get policy limits and liability? I know they're different issues, but what's the average time frame?
So that's a great question, and I can answer it in 2 ways. Number one, let's start with policy limits. It's a lot easier to answer that question. It shouldn't take longer than a week if you have the right information. Now, the right information includes defendant's, address, their policy information as far as the defense carrier that's on the case and the policy number itself. And sometimes with different carriers, it includes more information than necessary. But if you have like a police report available to you, that generally includes most of the information you need, and it shouldn't take longer than a week. And in some cases, if we need to, we can rush it and get that information to us in 12 hours or less if it's very important, like we have a pretty catastrophic injury that we're working with. So that shouldn't take longer than a week or so if you have that information. Sometimes it takes about a week or so to get that information. So any more than a month just on a fair end is long, in my opinion, to obtain that information and get it over to you guys. As far as liability goes, so the carriers have a time limit of when they have to respond to a claim and determining liability. And the problem with that is it's 40 days, but they don't have any recourse as to whether or not they comply with that request, other than stating that they need more time in writing. So what we like to do is we like to follow up with the adjusters at least every 2 weeks right off the bat to determine liability. And if we're working with a case that has liability issues with it, then we're going to provide that information to you as the provider and say, listen, this is going to be a liability issue case. We're all going to take risk on it. If you're okay with that, great. If not, we can figure something else out. But it's our job to communicate with the providers as to whether we believe, even if there's not a clear liability decision on paper yet, whether we believe liability is going to be an issue. And a lot of times, I think where this question is leading is that there's so many attorneys that will end up dropping a case months and months and months down the road with the answer of there's a liability dispute. And your question would be, well, why did it take so long to get that? Or you could have had your entire treatment done. And I just think that has to do with proper communication with the providers and with the law office on both sides. Dr. Razapur said that she doesn't generally communicate with the lawyers unless there's some big treatment that needs to be done. And my question really is, how can you get your bills paid in full 60% of the time and not communicate very much with the providers? Because the average cases that we're working on, we have limitations as far as what we can recover as a whole. So I think I'm not questioning it, I just think it's miraculous that you're able to do so, because we rely so heavily in our office for that communication so that we don't end up putting you as a provider in a situation for having to substantially take a reduction on your bill.
Brett, is that liability dependent on geographical area as well? Like, does LA get an answer quicker than Orange County?
No, these are all this is adjusters' issues. I mean, it has nothing to do with the jurisdiction itself. The adjusters determine liability and they do their own investigation. As far as police reports, LA takes a substantial long time. They're 3 months out on a lot of cases, and they're very slow. So if we are reliant on a police report, let's say it's a red light dispute, or there's some type of, it's not a clear rear end accident, then yes, it can take a lot longer if we need that police report. But there are ways to get the information that you need. You can get fixed speech. You can talk to the handling detective or the officer that wrote the report to get some information right off the bat. We like to communicate with the police departments so that we have that communication at hand in case we need it. But again, when we're dealing with a liability situation, we can be fairly confident that at the very end of the day, we have enough on our side to fight it in case we get a bad or poor decision. And a lot of our cases with liability disputes end up resolving full policy limits just based on comparative fault and the value of the case. So there's a lot you can do with that, even with the liability dispute situation. So if we had a case with a low policy limit of 15,000, and I have a client who was T-going an intersection, the airbags went off. At the end of the day, I don't necessarily care who's at fault, because at least partially the other person's going to be at fault enough for us to potentially get that full 15,000 and make sure that the client gets what they deserve from that particular case.
And Brett, we have our second question from Kenny Lee. How do you get your defendant policy limit?
So is Kenny asking the policy limits information, or is Kenny asking the actual, obtaining the policy limit?
It doesn't specify.
Okay. I think Kenny's probably talking about getting just the information itself for knowing how much we have available to treat with. And there's a couple of ways we handle it on both sides. There are third-party companies that attorneys can use and pay for to run searches in the background, just like insurance companies run searches on our clients. And so we utilize that on 99% of our cases, unless there's some carrier that we're almost guaranteed to have a lower limit on. And those are generally anything with national in it, general in it, Infinity, 21st Century, Kemper and Alliance, but there are bigger policies that we've seen recently come out of those. So we tend to like to run these policies just to be sure. And then on the back end, we like them to get confirmed, because I know that a lot of times attorneys end up getting again, a 75 to 80% confirmation rate on what is obtained versus what is actually available. So we like to work with the adjusters. We ask them in writing what the limits are, and they don't generally give that information up. In fact, in California, they're not allowed to unless they have consent from the defendant. And so we basically explain to them that it's in the defendant's best interest to obtain that consent. And if they don't give it to us right away and we desperately need it for some reason, we do send a follow-up letter, and we do like to utilize, this is getting a little bit complicated, so I apologize, but we utilize the fiduciary duty between the defendant carrier, the insurance company, and the defendant themselves as to what the insurance company has a duty to do to protect the defendant. And we kind of push them against each other so that we can obtain that consent. And we make the attorney or the insurance company sign off on giving our letter to them. So there are a couple of different ways. The easiest way is to use one of these searches. We have a list of probably 7 different companies that we utilize on any given basis, but it's pretty easy to obtain.
Hey, Brett, a question, kind of follow up on the earlier question, kind of since there's a big part of the audience that are chiropractic. What are the top 3 things you would say that chiros tend to do consistently to devalue the case? Give me 3 things that devalue it, and then 3 things that also help communicate, because we agree communication needs to happen. So let's talk about 3 positive, 3 negative.
Okay, so the 3 top things that can help hurt a case. There's more than 3, but I'll try to get the 3 biggest. Number 1, we don't get MRIs soon enough. It is vital that we want MRIs done, for me, within weeks of them being seen by you guys. 2, it's using self-healing diagnostic codes or soft tissue diagnostic codes that really devalue the case, because these insurance adjusters are using these codes, these grade 1 sprains and strains, to basically hold it in a soft tissue type of category. And most attorneys don't end up, working around that. So any treatment past that 6 to 8 week period where soft tissue is supposed to heal itself ends up being disputed pretty heavily, especially when you have other issues with the case, such as pre-existing conditions or low property damage. And then I think lastly is just not working collectively with a proper medical team as far as referring out at a proper time and trying to hold onto the case too long. And one of the reasons why that's not a problem isn't because we don't believe that your treatment is valuable. But most importantly, it's because the patient in a personal injury case has a legal duty to properly mitigate their damages. And if we're asking somebody else to pay for the medical bills that they're incurring, then we have to do it, our client has to do it in a particular way that is deemed reasonable within the legal community. And it kind of goes hand in hand with the definition of insanity, where if the treatment that they're getting isn't improving, then continuing that treatment expecting a different result is in its own definition insanity, and therefore won't actually make it very easy for us to get that additional treatment paid for in full value. So by utilizing a comprehensive medical team that can work up a case together, it makes for a much better result at the end of the day for everybody.
Perfect. And then three positives you would say that we are consistently doing that help increase the value of a case, or help you have a better approach at settling a claim.
Number one is what we're going to talk about all night, which is communication, proper and pure communication. You know, we have data on everybody with every adjuster and every insurance company, and you know, letting us know what you guys are doing with our clients is important to make sure that we can get things paid. Number two is documentation and proper documentation, simplistic, simplistic, digestible SOAP notes, which is another thing too. We don't want narrative reports. I know that sounds crazy to most providers, but we don't need you to spend the hours and the time and the energy writing out narrative reports or final reports or any reports. We simply just need comprehensible SOAP notes and reasonable bills. And then that's the last thing is reasonable billing, and understanding that a lot of times things that you can bill in a clinical practice is deemed unreasonable in a med legal setting. And a lot of that deals with passive versus active treatment. If a client can walk into a CVS and spend $10 or less on an ice pack, and they can get a 5-month or more, I'm just giving a small example, 5-month use out of that $10, then billing that same patient $30 every single time they see you to put an ice pack on their neck is not going to end up being reasonable. It's just going to look like bills are trying to be compiled to get a bigger settlement. And so that's the end game for us, is to present an extremely objective medical demand where the providers themselves do not look like in any way that they're trying to be biased. And I know that, you know, providers that work with us all the times and have my cell phone, which I'm happy to give out, you know, in the chat so that everyone can have it, utilize it at any time. We'll put it at the end, guys, so that you guys don't miss it. But we talk about this all the time. We know that you guys are taking patients on a lien. And irrespective of what the lien that our clients sign say, we all know that at the end of the day, your payment is reliant somewhat on the fact of whether or not there's going to be a settlement or not. And so the insurance companies know that too. And when we're trying to present a very objective and I can't believe I'm using this term in regular course and scope, I apologize, defensible or objectable SOAP notes, you know, we're able to get a much better presentation, and it doesn't look like you guys are trying to work the case up in lack of a better words, but just basically treat the patient. And so I guess my question is of the people on this panel, the doctors on this panel, how many of you guys are asked on a regular basis to provide a narrative report that takes you hours and hours to write?
You know, Brett, again, it's old school, it's standard behavior. This is new, what you're doing, just going through the SOAP note. But again, this goes back to chiropractic back in the day. They didn't even have a SOAP note. It was a travel card, right? So I think this process is maturing, that our SOAP notes need to be better to explain the story of what happened from the patient from day one. So I think that's what you see across the profession. We have a couple of questions that came in, and one was, again, about your communication. How often would you like communication with regard to status? And just to let everybody know out there, what we did at the beginning of the year that really helped out, I have one individual in my office, a key person with a dedicated cell number. She's our personal injury liaison. Every case manager, every attorney we deal with has her number. So it doesn't go through the office, it goes directly to that cell number, and she has access to everything. So they can get answers directly to their questions, and emails just so efficient. But how often that's one of the questions, how often do you like to hear a status on cases that we're treating?
So as far as if everything's going amazingly, not too often, enough to where we know what's happening. So if you're referring out for an MRI, just a quick note, we're referring this out to an MRI, so you should expect a lien from them, or you should expect a report soon. If we're referring out to a pain management consultation or a surgeon or some type of specialist, you know, just communication with that. And if our client isn't treating, so here's a big one for us. We talk to our clients every 2 weeks. We're very adamant on it, and we have constant reminders and meetings about how to make sure that that's happening on a daily basis. But a lot of times our clients aren't communicating with us properly. So when we ask them, how's treatment going? When was the last time you went? You know, whether they're doing it on purpose or not, sometimes we're getting answers that appears that they're treating regularly, when in reality, you know, when we get the bills and the records in, it's not the case at all. And we have weeks or months of gaps in treatment, and we never found that out for whatever reason. And, you know, our jobs are definitely to make sure that the treatment and our clients are being communicated with properly. But if you guys are finding as the providers that our clients aren't coming in, please let us know, like after one missed visit or 2 I mean, don't let it linger. It's important for us to know so that we can get that client back in your door. Because again, it's our job to work together to make sure that our clients get better and our patients get better. So it is a give and take as far as how often and case by case. But at the end of the day, I sincerely believe that we should be communicating, you know, biweekly or at least monthly on cases if everything's going, you know, perfectly and smoothly, or sooner if not.
Okay, and one other question I see here from Christopher Berry is, how important do you feel it is to attain advanced imaging, and how in the treatment program do you feel it's appropriate? My feedback, and I'd like to hear your responses, if the patient's either A, not improving, or they come in with ridiculous symptoms, that is time for an MRI right off the bat. Any feedback with that?
Yeah, so I'm going to echo that, but I'm also going to double down on it and just say, I would say right away. At the end of the day, the guidelines are pretty clear in allowing us to argue that it is not unnecessary or unreasonable to obtain that type of imaging in a traumatic event. And although it might not be medically necessary, it is not medically unreasonable. And at the end of the day, we have not once in the hundreds and thousands or the thousands of cases that we have, not once gotten pushback from an adjuster ever saying that an MRI was done too soon. In fact, the only time I've ever had pushback ever is when the client saw the chiropractor, got the MRI referral, and got into the MRI center in the same day. And they were like, well, that sounds suspicious. And we just kicked back and said, are you telling us that because our client found very prudent doctors and medical providers that they should be punished for that? If they waited 2 weeks, would you say that was too long? And if you push back on just a common sense argument, it ends up being dismissed at the end of the day. So I would say absolutely right after a traumatic event, if you feel and you do an objective orthopedic test on the neck or the spine, and there is any type of sensitivity, you feel palpation, you feel any type of, you know, stress at all, it is definitely reasonable to obtain, you know, that MRI. And in a lot of cases, I'm not a doctor, and I apologize if it ever comes off that I feel like I am, but I particularly would never want to touch anyone's neck or spine from a traumatic car accident or slip and fall or any type of traumatic event without knowing exactly what was wrong with that spine, because we all know that there are times where our clients can express very little symptoms and have a very serious injury or a premature narrow spinal cord, and that adjustment can just really mess somebody up. And I don't want you guys as providers to end up being put in that position.
I think your comment, I've never heard it phrased that way. It may not be medically necessary, but it's not medically unreasonable. I'm not
right.
That differentiation before. Well, by the way, MRI facilities, obviously, we all have preferences on who we use. We definitely have preference on ours. What in your mind differentiates one facility from another, aside from our preference in who we use?
I mean, at the end of the day, whatever's easiest for our client. You know, obviously there are certain centers that generate, you know, better reports or have better imaging, you know, actual machines. But for me personally, at the end of the day, I can always get the disc, and I can always have an expert or some specialist read that disc. So I believe whatever's easiest for the client is probably best.
Brett, how much pushback do you get for immediate pain management referral?
Okay, so that's a great question. And in my opinion, an early pain management referral can be a little suspicious. Only because I think that it's very reasonable for a client to be able to Google car accident, back injury, neck injury, and get chiropractic treatment all over the web. But I had no idea what a pain management physician was before I got into personal injury. And a lot of lawyers like to push out for ortho and PM right away to get that MD stamp on it. If you're gonna be one of the lawyers that practice that way, that's fine, but push to like a generic urgent care or a PCP. But we've had no problem. We use chiropractors on 99% of our cases that don't end up in the hospital right away for whatever reason. And we don't get pushback from that. And again, we don't necessarily get 100% pushback on a PM consult too early. It's just all that does is it adds $1,200 to the bills. And when you're dealing with when I'm dealing with a $15,000 policy limit, I'd rather get that $1,200 bill on the back end that recommends for future treatment versus the initial consultation, which should only push for conservative care at that point, unless they find something catastrophic in an MRI image.
So right now, if you send out an MRI as soon as possible, you send it out within the first couple of weeks, and patient has objective findings, you got orthopedic tests that are coming back positive, but you send the MRI out and it comes back with like a 1 millimeter bulge. What does that do to your case? How much pushback do you get on that?
So I think it all has to do with the injury itself, because we're all very well aware that imaging isn't 100% dictative as to what an injury is or the pain source is. And all that does is rule out significant disc protrusions. And it allows you as the chiropractor to do great adjustments and great therapy on that client without any risk or any issues. It's the exact same reason why there are x-rays done, but it shows everything an x-ray will show plus more to show all the muscular tissue and disc issues. So I don't find that as bad, and I'm not scared of it at all. At the end of the day, I'd rather have that than not have an image at all, and then 2 months down the road them try to argue that everything's degenerative because you don't see any type of acute injuries because all the tissue is dissipated and you're dealing with degenerative stuff. So I'm not scared of that at all, and I think that it should be welcomed by the community.
Great.
And it seems there's a question for all of our panelists, and that is, what are the most valuable modalities you use as a chiropractor?
Dr. Garcia, what about you?
I like electric stimulation, and we also have an intersegmental traction bed that we use, and sometimes ultrasound, depends on the injury. But those are the modalities I use that I like.
Brett, one thing too, again, what we try and do, just to add on to that a little bit, is we show a progression of care, right? So start with your passive modalities. At some point towards the end of care, add the active modalities. And again, it doesn't show the same kind of rubber stamp treatment each time. So that's something we really try and do and not just be very repetitive. It can be tough. I know now they don't pay for certain modalities, so you can say hot pack, ice pack, it's not needed, not indicated. So we try and mix it up a bit based on the patient needs. But do you have any suggestions of which are again, things that they're just denying consistently?
Again, it's more dealing with the active treatment and being able to bill reasonably. I know that a lot of the stims and the machines that a lot of providers use, they bill out very heavily, and a lot of times that ends up being disputed. But for us, it's really simple adjustments, massage therapy, and any type of physiotherapy that deals with active working with the patient itself. Because when it gets down to any type of litigation, a lot of times what these defense attorneys like to do is they like to look at your bill, and then they like to ask our clients how much time they spent with their particular provider. And if they're told, oh, I've got put on a bed for 25 minutes and they came back to see how I was doing, but they billed, $45 or $75 on that, it's going to be heavily disputed. And our job is to get the bills paid, obviously, in full and quickly, and by providing things that look that they're a little inflated, or there's not enough reasonable articulation to why that treatment was necessary for a personal injury case, then it delays that process. So, we end up liking very simplistic type of treatment when dealing in a personal injury setting. But I'd be very curious to find out what, the other providers on the panel do on their normal, workup of a PI case.
For us, active care is really the goal right away. So as soon as we can get them into some sort of therapeutic exercise, and our practice culture is based on sleep, strength training, stretching, it's getting the muscles long enough to the point where the range of motion is symmetrical on both sides. And as soon as that's there, they can get the range of motion clinically. Then you can start to actually build muscle. I mean, we just had a patient get a surgery for a 17-millimeter protrusion in his low back. And doctors told him within the first 2-3 weeks, he could barely pick up a coffee cup. But I mean, he's back to it. So as long as the patient is active in their mind, they're not kind of resisting it, you're giving them the inspiration to kind of start to mobilize and move correctly, it's going to be within a couple of weeks that you can get that patient on a resistance band, pulling 5-10 pounds of into a row. If they can't do it on their low back, they're keeping something positive. You guys have seen over the last 3 months where they closed the gyms, a lot of our patients are coming in with deconditioning syndrome. They're coming in with issues that they weren't having before, tendonitis. Their bodies can't really deal with the chronic states of sitting, and just the healthy patient can't deal with the gravitational pull anymore. Mm-hmm. Let alone a person who's been in a car accident, right? So you got a disc herniation that's coming in. One of the things that we do for cervical disc, we send them to acupuncture, have the muscles completely relaxed within the first 2 or 3 weeks, get them right into strength training, start to build the muscles as soon as we can. And those are the patients that fully recover. They're not corrected. They're not really going to pain management. We're trying to, as much as we can, try to avoid that, try to avoid the surgeries. And that's our job. But I mean, 95% of them are walking out healthy. So,
Dr. Razapur?
I do fully rehab treatment in my facility. I do have diathermy, infrared, interferential, laser, exercise, stretches, hand massage, and I do have a certification for low force, non-force, and manipulation. Basically, a little bit of everything based on the patient needs. And then I mix up the treatment, what patient need and what stage do we have to provide those treatment to the patient.
Awesome. And I think at the end of the day, I think what we want to do is, again, provide a type of plan that allows for an objective viewpoint and really work collaboratively to get that patient better. And, it's funny, I had a chiropractor call us today about a settlement. And I think as chiropractors, you should be very proud when a client does get all better in your practice without the need to move on to any other type of specialty. But those cases are far and few between, number one. And two, they're also very low valued type of cases, because at the end of the day, the pain and suffering of a case is not just the old standard of 3 times presented medical specials, but it also deals with the time and length of that pain and suffering as well. My wife was a very powerful and successful defense attorney. And yes, I stayed married to her the whole time. She's since been switched to our side. But she used to basically talk to these adjusters and explain to them, if the client is resolved of all their pain symptoms in, 4 months or less, then it's not going to be 3 times medical specialists. So it's very important that we know when we're working on cases like that they're going to be lower settlements, lower value cases, and that's okay, but we'll all work together. And I think, there's only so much that we can kind of get out tonight, but the goal is to communicate with each other so that we provide a more simplistic holistic and objective and defensible type of product that we can always defend in case it ever needs to go to litigation. I know that there are some other questions that I wanted to get to, so I don't mean to like dismiss that issue, but when it comes to the communication, again, one of the questions is how often at the end of the day should we want, or should the attorneys want the providers to follow up with us? It is definitely a two-way street, so I'm not putting this all on the provider's responsibility, but we should be communicating bi-weekly or every 2 weeks, just to make sure that everyone is on the same page, that there's clear documentation on both sides, and that we work together, because that's one of the biggest issues. And then another question is, and this is for all of us, and so we're all going to hit on this because I think it's really important. And I know it's been brought up in other webinars and seminars in the past, but let's get a clear, concise response to it. Is what is everyone doing to accommodate for patients during COVID? And although that things might have been lifted and patients are allowed to go into offices now, and quite frankly, if I'm not mistaken, I don't believe any COVID diagnostic number has ever been associated with a hospital or a doctor's office. So doctor's offices are generally the most cleanest places, but there are still people who live with family members who are at risk or are at risk themselves, or they're just scared to leave their home still. So what, as practitioners, are you guys doing to accommodate for that? And then after that, I'll hit on what insurance companies are doing with trying to defend that issue.
You know, Brett, what we started doing initially is there's patients who just were afraid, mostly fear, didn't want to come in. So we developed these home care kits, and we had an acute, subacute, and then a strengthening kit. So for our acute personal injury patient, that we do a telemedicine exam with them. If it was appropriate, we'd send them their first kit, which was a TENS unit, ice pack, analgesic cream, and herbal muscle relaxant. Then we do telemedicine to follow up to show them how to use all these items, which it would take a couple telemedicine visits. I mean, how does a chiropractor do telemedicine other than how are you, right? So then the second kit would be a hot pack foam roller, more pads for the TENS units, and analgesic cream. Then we'd follow with telemedicine, showing them how to use the foam roller, and depending on the area of concern. Then lastly, we'd send them TheraBands and or ball, et cetera, for strengthening. And that would justify more telemedicine to show them how to use this equipment. And subsequently, it's worked really well. You know, we're not charging $1 million for these kits. It's a responsible number, and patients are loving it. It's great. And it's developed a rapport and trust that they've actually, most of those people have come in for treatment for the manipulative component now. But that has been working really well with us. Obviously, there's a little financial component on our part for covering the overhead of these things that we're giving out, but it's been really well received by the attorneys who we've done this with and the patients for sure.
Yeah, I think it's a great idea. I think it's awesome. I for sure am pretty receptive to that. So that's great. Dr. Garcia.
Yeah, we've been blessed that most of our patients still come into our clinic. There has been some that do not want to come in because of COVID. So what we do is we wipe down every table after a patient's seen, sanitize our counters often. Of course, face masks are required in our clinic, and we social distance, even the waiting room, even our therapy room, everything. So we're compliant with COVID.
What about your patients that don't want to come in? Is there a way that you can still see them or communicate with them so that they can continue with some type of home active care?
Yes, and it is telemedicine. And,
Okay.
and again, that's far and few between, which has been very blessed for our practice.
Okay, and what do? Do you walk them through their home exercises, or just communicate with them that they're doing something?
Right, it's more you give them a regimen of home exercises and you communicate how they're doing, any problems, any questions, and that's about it. But just follow up on their exercises.
Awesome. Next, Dr. Razapur.
We have many safety measurements in our facility to make sure patients are protected against the COVID-19. All the patients required to wear masks. I have 15 treatment rooms, and then I have a sanitized machine in each room. And then, I change the sheet, which is coming from the linen company from the hospital. I change between each patient. And then, I try to keep the office safe and healthy for our patients. And then at the same time, for those patients, they can come to the facility. I do provide telemedicine. We have, FaceTime, Zoom, or through Google FaceTiming, and we provide stretches, exercise, and examination for the patient. If the patient needs to go for necessary testing, I will refer them out the patient for x-rays, for MRI. In my office, addition to chiropractic, I do have a pain management and medical doctors. If the patient need additional care, I will definitely refer them patient to those specialties.
Yeah, that's awesome. What about you, Dr. Tabrazi?
So for us, I mean, as far as keeping the office safe, it was strictly a scheduling thing, just kind of spreading out the scheduling. So it's one patient at a time in the waiting room, one patient in the treatment room. It's not overbooked. We have open adjusting rooms, so it's not overbooked at one time. But as far as sanitation, they come in, they see us cleaning the tables, we put our gloves on in front of them, that gives them a sense of confidence. But the funny thing has been, there's been two groups. There's been patients who don't want to come in because we ask them to wear face masks and we're taking temperatures in the office. So there is that group as well, and the anti-mask, sort of group, and we accommodate them as well. We say there's certain hours that we have, and we're going to give you a private room, but you can't be in the same room as other people. So there's a certain hour slot that we allot for people who are uncomfortable doing that. But a lot of people have really strong convictions about things like that, and we don't want to keep them from coming in for care. But I mean, everybody's trained to take care of, taking everybody's temperature, making sure everybody's safe. And, we're testing our employees. We're sending them for swab tests. We're making sure that they're, they have no symptoms, that even their tests come back negative. So,
right. And we do that too. And I think that that's important. And I love that everyone has a different answer to that, I guess. I think it's amazing how we've had to kind of adapt to the times and really be able to do whatever is necessary to help the clients and the patients. And so I'll address that kind of from the legal side of things. We haven't really gotten a whole lot of pushback when it comes to anything relating to COVID. Delays in treatment, communication with the clients and the providers. It's very reasonable, especially, since March. I mean, things are lifting up now, but again, it is extremely reasonable that people are still fearful of leaving their homes or entering into an establishment with a lot of people around. And so what we do is, we basically explain to the carriers why it's reasonable. And at the end of the day, that's what a gap in treatment really is. It's a way to define what's not reasonable. So if we can communicate and articulate to the carriers why their gap is reasonable, then there's really not much argument that they can rely on. Because if it's fair, and a lot of it comes down to the common sense arguments, and COVID is a really good way to articulate why someone can't treat or doesn't want to treat, but is still in pain. So we like to have them document it or figure out a way, even if it is literally just calling the chiropractor and writing down symptoms to state that is still, something that they're still going through, can be valuable to that. But we haven't gotten a whole lot of pushback on the COVID side. So, I know that we're coming up on an hour. I'm not even sure how much time we really aside for this, but we have a ton of people still on it. Are there any other questions, either from staff members, lawyers, or chiropractors, providers, or any other type of specialist watching that we'd like to address today? I mean, we only got to probably a very nominal amount of what we're trying to do here as far as push this towards okay, boy, you're good. Thank you. Over here.
Dr. Choi had another good question. He said, chiropractic average visit bills, what do you like seeing per visit, just so you don't get a lot of pushback? I know we all bill per area, zip code, et cetera, but is there an area where you see pushback? What's that sweet spot?
So yeah, when bills are extremely high, adjusters come back and they're like $100 a visit, which is unreasonably low, in my sincere opinion, right? Unless something went wrong, we're asking for a reduction. I mean, that's usually where the sweet spot is. But when we see bills on average between $120 and $180 a visit, we don't get pushback for the most part. I mean, we have adjusters that if they're giving pushback on anything, they're saying, well, we're paying your chiropractor bills in full. And I've even had chiropractors say, well, they would never say that. Like, I have it in writing. You know, they will pay those bills. Those are not something that they can dispute on average, because they are very reasonable, especially when it's not just an adjustment, when there are other things that you're billing for within that session. But when you get into the 200s, and I've seen 300s and 400s, that's when we come and get into the issues, and they like to dispute, and they like to delay, and they like to, you know, figure out ways to devalue the case, just because they don't simply believe that it's something that's there. And I'm not going to sit there and tell you that if we receive bills like that, that we're going to sit down and let an adjuster dispute it. We'll fight it. We possibly can. But you know, we all are aware of, you know, what ends up happening when an adjuster wants to pay, you know, medical specials or lower than medical specials. I'm sure you guys have all seen those reduction requests where the settlement was less than what the medical bills were. So $120 to $180 a visit generally is the sweet spot.
Yeah, makes sense. Perfect.
So an anonymous attendee, very brave of them, asked about MedPay. That is obviously a very difficult topic to talk about when you're dealing with lawyers and providers. So let's, okay, sorry guys, I apologize. She's very needy. What I will say about MedPay is that our firm likes to handle things a little bit differently. We like to have MedPay available for our patient, because a lot of times they don't have money to pay hospital bills, ambulance bills, and when they don't have health insurance, the emergency care providers are not the ones that will reduce, and we need to pay those bills, and we like to get them before they're done in collection. So we do like to control MedPay with that regard. And then on the back end, if something goes south, I want to make sure the MedPay is there to get your bill paid. But if MedPay is being used up front, it's very difficult to make sure that the client is able to utilize that for their best ability towards any particular fact pattern in a case. We're not going to hide it. We're not going to keep it from you. It's not something that we like to do. We do love to use it in liability dispute cases, so that should have been addressed earlier, and I apologize for not, but there are definitely times where our office will ask you to bill MedPay, or ask you to send us a bill so we can bill MedPay, especially when we're dealing with a situation where we have, you know, a potential dispute in liability, but we can make sure that they at least get some care done. And a lot of times, I know this sounds absolutely crazy, when we get calls where our client is at fault, we'll ask them if they have MedPay, and if they do, we'll refer them to a chiropractor that is in their area, and we'll tell the chiropractor that we're not representing the patient because they're at fault, but by all means, get them some good medical care because they're hurt. And as we know, MedPay is a no-fault type of coverage, and they can still do that. So we're not one of those firms that likes to keep MedPay from the providers, but we do like to utilize it in the best care for our clients in any given circumstance, if that makes sense.
Yeah, I have a kind of a touchy subject since we're on MedPay and the touchy subjects. We've all had the reduction phone call, right? Wanting to do a reduction. A lot of times we found we're lied to, obviously, about whether it's MedPay, or I'm sorry, whether it's medical bills. What's your feeling? Everybody talks about pro rata share. You hear that all the time. You know, the legitimacy of this. We even have attorneys saying, well, we're going to cut you X amount below the pro rata share, in which we obviously don't accept it. You know, what's your feelings when you have an attorney? I know you don't do that, right? So reductions, what's the feedback? Because I think everybody on this call has been in that position and looks for guidance, and, you know, really don't know where to get that guidance.
Of course, and I had a couple of conversations this morning with a couple of providers with the same issue. And really, I will tell you if I believe that the reduction is fair based on what is presented to you. But in most cases, that's not the case. Pro rata is a term that most attorneys use to figure out a way to reduce bills. So they like to take a third of the settlement, whatever that is. Let's say it's $5,000. And they want to take your bill in proportion to what the total bills are, and whatever that percent is the percent they want to offer you of that $5,000. And I guess on paper that seems fair. I understand the concept, but in reality, what ends up happening is that your bills are being cut at the same rate as, again, a pain management consultation, which is highly inflated, as well as an MRI bill, which is highly, highly inflated. And there's no reason why you as a chiropractor, who is the one basically building the case, treating the patient multiple times for months and months and months, sometimes longer, should get the same cut as anyone else on the case. If we go further and there's an injection done, I mean, the cost of an injection, I'm not going to get into that on recording, but at the end of the day, it is definitely not what the difference of is on your bills. And I don't believe that anyone should take a generalized pro rata approach when dealing with any type of reductions. I think it's a case-by-case analysis, and at the end of the day, what is your bill, and whether or not what you presented to be objectively reasonable. And I like to work with the providers that know that if you present a credible case and a reasonable global bill based on the information that I provide to you, one way or another, I'm going to try to get you paid, and that might mean having to go into my pocket to get it done. But if it wasn't your fault, I'll let you know it's our fault, and we'll work together to figure this out. But I want, and I don't know if this is happening, but I've heard a lot of chiropractors say this, the time where the chiropractors just take what's being offered and go towards the generic, we'll get you on the next one type of approach really should end. We should really move towards a better movement.
Absolutely. And Dr. Rapport mentioned earlier, she requests like the breakdown. I think we all do. We're hearing every now and then you get one of these firms that are just out there where they refuse to give you a breakdown or any of the supporting documentation. Do we have any rights as providers to request that information? And are we due that information if we're going to take any type of reduction?
Again, it's a case-by-case situation, and it kind of boils down to what's in your lien, as far as what information is presented and how reasonable the bill is. A lot of times, if we have a global settlement and we have limited amount of money to go around, and your bill is objectively high for that scenario, if we're offering a reasonable bill per session, like let's say I'm offering you $150 a visit, sometimes it's not necessary to provide the other information because maybe I'm cutting another provider substantially more to make sure that you get the 150. And it's not fair to that provider that I'm doing that. So it really is a case-by-case analysis, and I believe that it all comes down to what attorneys you work with and the trust and the relationship that you build with them as far as what information is provided and when. I know that we work with providers all the time where we're paying them well above market rate on nearly every single case. And then the one time we ask them to take a hit because something went wrong or we have an issue with the case that we might not be able to divulge, they get really upset when we don't provide them that information. But sometimes there is a situation that we can't tell you about, but we're asking you to trust us. And again, I'm not asking you to do it on every case, but when I do, it's far and few between. And our job is to really create relationships with our providers to make sure that we all understand that we're in this together. And when I'm asking for a haircut, a lot of times we're taking one as well. And it's far and few between, but we're generally very communicative with our providers and give information that's needed to get a resolution.
Awesome.
I have a question.
Of course.
Regarding the MRIs, you mentioned you recommend to get the MRI within first week. Usually in the auto car collision, as the patient has symptoms of a neck pain, shoulder pain, back pain, the number of this chief complaint is a lot. If you start getting the MRI first week, we have to take 3-4 MRI region. How would we justify, first of all? And then what is your recommendation?
I guess I would concentrate on the most complained about area. And again, it does come down to the information that we give you, right, doctor? If I say that we have a $100,000 policy, then by all means, if the client's complaining of, you know, three very specific areas, then let's get 3 MRIs. If we're dealing with a $15,000 policy, it's a very different story.
But is that going to be work up the case?
I'm sorry?
Is that going to be something that, you know, like, you know, don't you think we should wait for a couple of weeks to make sure the, you know, correct region, because patient symptom and sign will be changed from the first week to the 3rd week, you know,
That's a great question, and thank you for clarifying, so I understand it and can address it a little bit better. Yes, but a lot of times the doctors can really address that with the patients, and I think that with the experience that you have and the time that you spend with your patients, I have faith that the doctors can get out the most serious body part, and generally it's dealing with the neck or the lower back, depending on the case. But I have all the confidence in the world that you can really get to the nitty gritty with the patient and find out which body part is more serious so that you can concentrate on that body part first.
Thanks.
Brett, for our disc patients, they come in with like 4mm disc protrusions or like L4, L5. It's really common. We use like LSOs, back braces, and they're really effective. But DME isn't really covered with any of the insurance companies. Do you see that going in a different direction in the future or no?
Okay, so for some reason my volume was down. Can you say that one more time?
As far as DMEs go, like lumbar braces, back braces, do you see that changing in the future for how we get reimbursement on that?
No, not in the very near future. I mean, you know, back braces and neck braces are generally used for very serious, you know, neck injuries. And if, in my opinion, again, I'm not a doctor, but in my opinion, if I'm thinking about it objectively, if a client's being presented with a neck brace and their neck injury is that severe, then chiropractic treatment's generally not going to help with that. And it should be definitely sent straight to a specialist. So to be quite honest with you, I mean, it's a case-by-case analysis as to whether or not you medically believe it's necessary. But I don't see that being reimbursed in all cases. It's going to be hard to. But you know, we're going to fight for every type of reimbursement there is. But I'd be very careful with, you know, what patients we see with neck braces on. Generally, if I see a client with a neck brace on, it's sometimes a little questionable.
Yeah, I agree. Neck braces for sure. Those are. I don't think I've ever prescribed a neck brace to a patient, but there are certain, they call them lumbar support orthoses. They're the back braces that really stabilize disc herniations, okay, especially at L4, L5. L5S1 disc herniations, they don't really do much for, but L4, L5, you adjust it, put it in a quiet environment, it starts to heal relatively quickly. And I'm surprised they don't cover it because it would save the insurance companies money. But I was just wondering if there's been any discussion on that, because I know there's some third-party companies that will come and kind of try to bring chiropractors and say, hey, we'll take it, and you know, we don't work with them. But
I would stay away from those companies, just to be quite honest with you. I mean, a lot of times, you know, that's not something that's going to, at the end of the day, completely heal the patient and fix that disc issue. And that's the goal, right? I mean, the goal is to get the client pain-free and to fix the injury, if at all possible, in a med-legal, you know, type of setting. So I would be very wary of those companies coming in and trying to sell you on all this equipment and this very expensive machinery, and it doesn't get reimbursed dollar for dollar. And you can definitely use it on cash patients and clinical practice, but it's very hard to get that kind of stuff paid for at the rate that it's been billed out for.
I hear you.
So again, I think we could talk about this for days, if not, you know, months. But we are over our hour, and I was told that we want to do an hour. So I appreciate the fact that it appears that we have everyone pretty much from beginning to end. And I'll put my contact information in the chat for everyone to see. And I want to thank everyone, the providers on this panel, as well as, you know, Doctors on Liens and Injury Institute. We appreciate everything you do for our clients, and this is an awesome opportunity just to talk collaboratively with the providers and try to start for the future.
Thanks, Brett. Appreciate it.
Awesome. Appreciate your taking the lead in trying to change this thing, Brett. It needs some change.
Thank you, Doc. We appreciate you.
Thank you all.
Thanks, everybody. Take care. Have a great night.
Bye.